and he allowed a current sitting president to assert privilege on previous administration's papers. What this did was it created a threshold standard over old documents where an incumbent or a previous president could declare privilege on documents and withhold those almost indefinitely from the public. In addition, the executive order stipulated that in order to look at these papers, even if they're not privileged, that you need to have a demonstrated specific need for them. A high threshold, one that Congress didn't intend when it passed the Presidential Records Act of 1978. Some members of Congress were upset. There was very little pushback, as I said. For the most part, the Republican Congress never pushed back on President Bush after the DOJ case that I just talked about. A number of interest groups, academic interest groups, sued in federal court over this executive order. Late last year, a D.C. District Court judge struck down a portion of the Bush's executive order that allowed for former presidents to indefinitely withhold information from the public. So, a slight victory. However, I'm a little bit hopeful that, and Professor Burke mentioned that President-elect Obama is currently reviewing Bush's executive orders, and I'm hopeful that that's one of them that he will modify. There's no guarantee on that, but if you want to know where President Obama is going to go in terms of executive privilege and presidential powers, you focus on that executive order. If he modifies it to how it existed before a pre-Bush presidency, that'll give you a good, clear indication of where the Obama presidency is going to lead, at least in terms of secrecy and executive privilege. Now, the third case, I should say, is one where executive privilege was not claimed. However, this case greatly expanded, in my view, presidential power. This is the Energy Task Force case. What had happened is shortly after the energy crisis in 2001, President Bush established an energy task force within the Vice President's office, headed by Vice President Dick Cheney. Dick Cheney held a number of meetings with high-level energy executives. It came to light that a number of these meetings, there was Enron officials. Not too many environmental groups were allowed into these meetings. So there was a question at least raised on the propriety of these and access of certain interest groups and individuals. And Congress, as was typical in the first half of the Bush administration, didn't investigate. Republican Congress didn't investigate. It took Democratic Representatives John Dingell and Henry Waxman. And if anybody knows what's going on right now with those two, you'll know that they're not the best of friends. But at least during this time, they were investigating this matter. They asked for documents from Vice President Cheney. Vice President Cheney's legal counsel, David Addington, basically runs legal circles around them. They're prevented from accessing this information. They request that the Government Accountability Office investigate the matter. Again, David Addington runs legal circles around GAO, and then eventually two interest groups, Sierra Club and Judicial Watch, pressed this in a district court case. What they were doing is they used the Federal Advisory Committee Act, which is a federal law that mandates certain openness requirements of executive branch advisory committees, which was what the Energy Task Force was designed to be. The district court allowed these interest groups to go forward. They actually started the discovery process. Cheney's people appealed. This case went all the way up to the Supreme Court. Supreme Court accepted this case. And what the Supreme Court said, and they vacated the lower court's judgment and said that separation of powers are a vital concern in this case. Again, I remind you, executive privilege had not been claimed yet. The court went on to say that the need for information in civil cases does not rise to the same level as a criminal case, directly alluding to U.S. versus Nixon, so distinguishing the two cases. Speaking for the court, Associate Justice Anthony Kennedy declared that the lower courts, and I quote, must give recognition to the paramount necessity of protecting the executive branch from fictitious litigation that might distract it from the energetic performance of its constitutional duties. Now, I don't get quite teary-eyed that the executive branch needs any help to perform in an energetic manner its constitutional and presidential duties. And I don't think that the courts need to protect it either, and certainly not from Judicial Watch and Sierra Club, two interest groups. This case I consider to be, unlike some of my colleagues, to be a significant opinion, and I think it's one that the executive branch has used since then to bolster their position that Article 2 gives them greater power. And it actually did this in the latest case in terms of executive privilege, and that is with the U.S. attorneys. Most of you might be familiar with the case. It's 9 U.S. attorneys were removed from office in 2006. 2007, a congressional investigation began. Democrats obviously were in control then, so a congressional investigation started in the House and Senate Judiciary Committees. Some papers were released, but by and large, the executive branch said no to disclosure. What happened was executive privilege was claimed so far 4 times. In 2 of those cases, one dealing with former White House counsel Harriet Miers, the other dealing with Chief of Staff Joshua Bolten. The resulting district court case really centered on those 2. And what I mean by that is Bush claims executive privilege on these 2 individuals. In Miers' case, Miers was asked to testify before Congress, and typically with executive privilege claims, the executive branch official will appear before Congress and then exert executive privilege on a question-by-question basis. Miers didn't do that. Miers said, I'm not appearing, and I'm not appearing because Bush told me not to. And what Bush based his decision to tell her not to appear was the claim of absolute immunity. Now, this is a new legal standard created. It's not one that has been adopted by previous executive privilege cases or any other cases that I am aware of. Now, absolute immunity basically is this. Executive branch officials, all of them, if an absolute immunity claim is made, do not have to appear before Congress, even if subpoenaed. Congress had subpoenaed Miers. Congress actually held her in contempt. Also, Joshua Bolten, in his capacity as the keeper of administration records. And the contempt citation was given to the Department of Justice. Department of Justice said, no, this contempt citation we're not going to move ahead and prosecute because it doesn't arise to the level of a criminal matter. So the House had to sue in federal court. And just for a mention of just full disclosure, I co-authored, along with Mark Rozelle and a few other political scientists, a amici brief in this case. And this case centered around the claim of absolute immunity. And what I mean by that is you have on one side Congress saying, we need this information, we need this person to testify. If you're going to claim executive privilege, at least appear before us and claim it on a question-by-question basis. This isn't something Miers did. So the House goes to the court to have them throw out the absolute immunity claim, which earlier this fall, the D.C. District Court Judge John Bates declared that absolute immunity has no basis in the Constitution, case law, or history. I will say that there is no, at least I know of no example where an absolute immunity claim has been made in this type of case had come about in prior administrations. So with that said, to summarize the Bush presidency, he's adopted this expansive view. I believe that it's largely flawed. I think his legacy is going to be one of, again, what not to do. And hopefully Obama is going to take what President Bush has done in terms of U.S. Attorney's case and other like cases and say, I want to be a little bit more accommodating to Congress and not necessarily stonewall them every attempt I get. Thank you very much.